Good afternoon, everyone. I hope you all had an adequate lunch and we're prepared for the second session. Hi, Mr. Hoskins.
Thank you, my lord. I've just got a few very brief words to say on the first issue, and then I need to obviously crack on with the second issue in the time left to me. The final comment on the first issue relates to Canadian law. And you'll have noticed that the applicant's written case relies heavily in its submissions on Canadian law, not just the Process and Microsoft test, but also some lower Canadian cases. But I just want to make some very simple points about Canadian law. First of all, the interpretation and application of the Act and tribunal rules is a matter of English, not Canadian law. Sorry to state the obvious. The second point is that the approach of Canadian courts is informative, but no more than that. The third point is that the interpretation of the UK regime cannot change each time a new Canadian judgment is adopted. We are clearly not.
I think you could probably accept that we don't dispute that.
That's a relief, because otherwise I really would be making heavy weather. I'm grateful for that indication.
While we pay very, very great respect to Canadian jurisprudence, we're not bound by it. It doesn't seem to me that it's exceptional to suggest that we don't change our law automatically, the consequence of a decision in the Canadian Supreme Court, however much regard we have to their decisions.
I'm grateful, my lord. The next point is, of course, that it wouldn't be appropriate to seek to rely on the way in which Canadian law was applied to the facts and evidence in a particular case. The relevant question for all of us today is, what does our domestic legislation mean? Not what do the Canadian courts say that Canadian legislation means, which is my previous point, or how have the Canadian courts applied Canadian legislation to the facts of particular cases? That's really not going to take us anywhere. Now, the tribunal adopted or referred to a Canadian test in its judgment, as we've seen, rather than a more traditional English law approach, when they haven't simply gone to another aspect of English law and picked the test from there. They've looked at Canadian law. And the reason for that is, of course, the experience of the Canadian courts in dealing with collective actions. And it is important to bear in mind that this is not litigation of the sort we are used to, by which I mean that collective proceedings are a new world for English law. This is the first time we've had this particular type of collective proceedings on our statute book as a possibility. And that new world is a world with different requirements from those we are used to dealing with. And you see that in the certification requirements that are set out. You've had my submission that Parliament indicated, or is in the legislation it laid down as indicated, that certification is not the same, for example, as a merits consideration. There are separate provisions in the Act that deal with summary judgment and strikeout and in the rules as compared to certification. And therefore, that's one of the reasons, as I explained this morning, why one can't simply assume that the reasonably arguable case test that we're all used to in civil litigation between individual parties can simply be read into this legislation. And indeed, in our submission, it'd be dangerous to do so when Parliament could have written in reasonably arguable case into the certification criteria, but chose not to do so. And ultimately, in our submission in relation to issue 1, the question is whether the legal test applied by the tribunal was one that was permitted under our legislation. And in our submission, it clearly was. And unless you have any further questions on issue 1, I was going to move swiftly on to the second issue, which deals with distribution.
Well, I think probably we can move on to the second issue.
Thank you, my lord. So the second issue concerns the manner in which the applicant proposed to distribute any aggregate award of damages to the individual members of the class. And we need to begin by looking at the limited, admittedly, legislative provisions that concern distribution. First of all, MS 1186 which is Rule 92 of the Tribunal Rules.
Yes.
Again, I'm sure you've all read these. First of all, note the heading, Assessment of Damages. So this is dealing with where an aggregate award has been made and it is being decided what the individual members of the class should get. And the author of the rules used the heading Assessment of Damages, which indicates that the amounts paid to the members of the class are damages. The second point is that where 92 sub 1 provides where the tribunal has made an award, an aggregate award of damages, it must give directions for assessment of the amount that may be claimed by the individual members of the class. Rule 92 sub 2 sub A, the directions given may include a method or formula. That is all the legislation says about distribution. Quite clearly, the tribunal has a very wide discretion as to how aggregate damages awards may be distributed. One does find something else in the tribunal's guide, MS 1172. Yes. Paragraph 6.83. I pick it up really 4 lines down with the words towards the end of the line. Typically, the defendant will not be involved. Typically, the defendant will not be involved in the process of determining how the award is to be distributed amongst the class. So what the guide is saying is that after an aggregate award of damages has been made, typically the defendant will not be involved in deciding how it is distributed. But the use of the word typically tells us that the tribunal envisages that whilst normally a defendant will not play a part in distribution, that will not always be the case. It is anticipated as being possible under the guide that the defendant may play a role in deciding what distribution is appropriate. And para 6.3, the tribunal will be concerned to ensure that the method proposed by the class representative is fair to the interests of all class members. But there really is very little in the way of guidance as to what the tribunal is supposed to do when considering distribution. The second independent reason, as you know, why the tribunal refused certification was because the method of distribution proposed by the applicant bore no relationship at all with the compensatory principle, tortious damages, and that it was impossible to see how the awards to individual class members could be determined on any reasonable basis. Come back to the tribunal judgment. The Court of Appeal held that the tribunal committed an error of law because according to the Court of Appeal, the tribunal had assumed that, as a matter of law, it was necessary that in all cases, distribution must be carried out on some kind of compensatory basis. So that sets the turf, if you like, for what we're going to be considering. But before we look at the judgments in any detail, it's necessary, first of all, to see how the argument was put before the tribunal. Can we go, first of all, to MS 305, which is the collective proceedings claim form. It's paragraph 47. Yes. And you'll see there, so this is the applicant's claim form. A determination will then need to be made as to how to allocate the aggregate award of damage to members of the class. The proposed class representative's present proposal is set out in the collective proceeding litigation plan. And if we go to MS 2926, you will find that litigation plan. So you'll see the front page, collective proceedings litigation plan, and I'd like to pick it up at 2945. Paragraphs 80 to 81. And perhaps I could ask you to read those paragraphs briefly, because you may well not have read those before.
Sorry, 2945.
2945, paragraphs 80 to 81, please.
Thank you very much. Yes, thank you.
You'll see from paragraph 81, therefore it was the applicant who at the outset in his application suggested that distribution in this case should take account of the need to make the award of individual damages as compensatory as possible, having regard to all the other factors. Now, Mastercard's response to that application is at MS 362. And paragraph 67 sets out some extracts from the applicant's litigation plan, including the one we've just seen. And then over the page at paragraph 68, you'll see how Mastercard addressed the issue of distribution. Again, you've probably not seen this. If I could ask you to briefly read that yourself, please.
Yes.
So that's what Mastercard said. And then finally, the applicant had a reply as part of this process, this pleading process. I'd like to pick it up at MS 422. So this is Mr. Merricks' reply, paragraph 13. And again, I'd invite you to read that briefly, please. Particular note the line in the sentence in the middle. However, the tribunal and indeed Mastercard may rest assured. Mr. Merricks is saying the tribunal and Mastercard may rest assured that we all sing with one voice on this issue. Distribution should be as compensatory as possible. That's the applicant's words. Therefore, before the tribunal, the applicant's position was that distribution in this case should be as compensatory as possible, his own words. It wasn't argued either in writing or in oral submissions, and we've checked the transcripts, that there was no legal obligation on the part of the tribunal to have regard to compensation when considering distribution, or indeed that there was such an obligation. The debate wasn't put in terms of a legal obligation or not. It simply wasn't an issue. It wasn't an issue because the applicant himself was saying that distribution in this case should be as compensatory as possible. And in our submission, it's important to bear these points in mind when we come to read the tribunal's judgment, which is where I now turn. Can we go to MS 254?
Yes.
Paragraph 46, first sentence, you'll see that the applicant, or Mr. Harris on behalf of the applicant, accepted that distribution was an issue that could be considered at the certification stage. That's the first sentence. And then the final sentence of paragraph 46, you'll see that the distribution method proposed by the applicant was one of annualized per capita distribution. All that means is that you take the aggregate loss, you calculate it on an annual basis for each of the years of the claim, and it's then distributed on an equal per capita basis among each of the members of the class in that year. That's what was proposed. And then paragraph 47, when pressed on this matter by the tribunal, Mr. Harris responded that various methods of distribution had been considered. And then over the page at 255, if you go down 1, 2, 3, 4, 5, 6, 7 lines, there's a sentence that begins towards the end of the paragraph or the side of the page. However, Mr. Harris made clear that the applicant did not regard any of these alternatives as attractive or indeed appropriate. Then the final sentence, the annualized per capita distribution was the only one put forward as appropriate and practicable. So that was the applicant's position. This was the only method of distribution that he suggested could be appropriate and practicable if an aggregate award of damages were to be made. Let's look at the tribunal's findings on this. MS 265. Its analysis begins at paragraph 79. Now, in our submission, the proper reading of the tribunal's judgment is as follows. It was common ground between the parties that distribution in this case should bear some relation to compensation. I've shown you that from the pleadings. In their oral evidence, the applicant's experts stated that the proposed method bore no relationship to the individual loss of the class members. If you go to MS 267, you see that in paragraphs 84 and 85. And the particular point I want to note is the final sentence of paragraph 85. When the two experts were asked about this method by the tribunal, they readily agreed that the proposed method per capita distribution on an annualized basis bore no relationship to the individual loss. Third point, the tribunal held that the applicant's proposed distribution methodology bore no relationship at all with the principle of compensation, consistent with the applicant's own expert's view, and also the tribunal held that it was impossible in this case to see how the payments to individuals could be determined on any reasonable basis. You see that at bottom of page 268 in paragraphs 88 and 89. You see at the top of 89, it is the significance of the individual issues remaining, which mean that it is impossible in this case to see how the payments to individuals could be determined on any reasonable basis. And you remember that's against the backdrop of the applicant saying that only one method was an appropriate one to be considered. And then you find the final sentence that the proposed methodology would not result in damages being paid to those claimants in accordance with the governing principle of compensation at all. It's the complete absence of relation to compensation, which is the problem here. The tribunal did not refer in its judgment to the existence of a legal requirement that distribution must, in all cases, bear some relationship to individual compensation. That's understandable because that was not an issue that had been raised or argued before it. I've shown you the way in which the argument arose and was put. The tribunal gave that judgment. The applicant applied to the tribunal for permission to appeal. One finds that at MS 2946. This is the applicant's application for permission to appeal. It's the application to the tribunal for permission. Can I ask you please to turn to page 2956. You see the heading ground to distribution and then the subheading A, the tribunal erred in law in holding that distribution must be individually compensatory. So in spite of the position that the applicant had adopted before the tribunal, as I've shown you in the pleadings, in his application for permission to appeal, one of his proposed grounds was, well, you see what it is. And clearly what happened was that having read the judgment, one of the very capable lawyers acting for the applicant said, oh, I've got an idea, let's run this point. But it looks like they did that without checking the way in which they'd put the case in their own pleadings to the tribunal.
Well, it's not exactly unheard of for a party to change its position on a particular point.
Absolutely, my lord. But the question we're going to come to, a crucial issue here, is whether the tribunal actually did make a finding that as a matter of law, there must be a relationship to compensation in all cases. And that's why clearly when one comes to construe the tribunal judgment, it's important to see the way in which the parties put their arguments before it and what was and was not an issue before the tribunal. But I accept the point you put to me, my lord.
But does, I mean, has the tribunal decided in your submission that it must be compensatory, the distribution of the award must be on a compensatory basis?
No, and I'm going to show you where it's actually said that that's not the case. If we can go to, because I showed you the applicant's application for permission to appeal, and what I now wish to show you is the tribunal's judgment in which it refused permission to appeal. and that's at MS 233. And if I can ask you to read paragraph 19 on page 233.
Yes.
And it's particularly the sentences beginning contrary to what is stated and as noted in the observations from Mastercard. See in particular the words, it is a mischaracterization of the judgment to contend that the tribunal found that there were substantive legal requirements which the proposed distribution model must meet. And that's it specifically in response to the permission arguments raised by the applicant. So I make 2 points in relation to that. First, I do say it's unfair for the applicant to complain that the tribunal had regard to the compensatory principle when it clearly did so in its judgment, when it was the position of the applicant itself that the tribunal was entitled to and should have regard to the compensatory principle. And the second point I make is this. The tribunal confirmed that it did not proceed in its judgment on the basis that there were, quote unquote, substantive legal requirements pursuant to which a proposed distribution model must reflect the individual loss of individual members of the class. So it wasn't raised in that way before the tribunal, and when it was put to the tribunal that it had found that there was such a rule of law, the tribunal said, no, I'm sorry, you've got that wrong. Lord Leggett has a question.
Yes, Lord Leggett.
Hoskins, I can understand an argument that the substantive law of tort requires individuals to show they've suffered a loss in order to recover damages, and that the legislation should not be read as ousting that rule of tort, but rather as a procedural mechanism to enable individuals to group together and make claims. But you seem to be at great pains to disclaim that argument, to say that that is not the case you're putting forward.
Yes.
And once you've given that point away, then your point seems to be hopeless, or what's left of it, because then it's a question of trying to be as compensatory as you can. But if you can't be compensatory, you don't have to be, because there's no substantive requirement.
Yeah, but my lord, what you must bear in mind is that, again, the legislation gives the tribunal a wide discretion as to whether it considers distribution proposal to be appropriate or not.
Yeah, but that's at a much later stage. If you want to rule it out at the outset, surely you've got to show that it's out of bounds altogether.
Well, there's two issues here, and we'll come to that in the Court of Appeal judgment, which I think will address both your lordship's points to me. The first one is, the way the Court of Appeal put it was that the tribunal had wrongly assumed that there was a legal requirement that distribution must in all cases be carried out on some kind of compensatory basis. My submission is that is not the basis the tribunal proceeded on. The tribunal did...
Well, I'm sorry, but just look at the first sentence in paragraph 19 on page 233. The tribunal held that the introduction of the collective proceedings regime has not changed the fundamental nature of damages for breach of competition law as being compensatory.
Yes. So therefore, the tribunal was entitled to have regard to the extent of compensation when it decided to approve, or whether it would approve, a proposed distribution mechanism. There's a distinction between there's a legal requirement that distribution should be carried out in accordance with the compensation principle, and the separate legal question of whether the tribunal was entitled to take account of the degree of relationship with compensation in deciding whether a distribution model was acceptable or not.
Well, if it is the fundamental nature of damages for breach of competition law that it be compensatory, how could the tribunal leave that out of account, whether by way of concession by the applicant or otherwise? How could they leave that out of account in deciding whether a collective proceedings regime should be instituted in this case?
That's in a sense where we're coming from, because we say that the tribunal did have regard to compensation and it was entitled to do so under the legislation. That's the way we put our case.
Oh, I see. Well, I'm sorry, I've misunderstood your submission then. I had thought that you were submitting that the tribunal did not find that it was a requirement that it be on a compensatory basis.
Can I show you what the Court of Appeal said, just because it's quite a nuanced point that the Court of Appeal took. And if I develop that, then hopefully you can see what the Court of Appeal was saying and why we say the Court of Appeal was wrong.
Well, possibly, but I'm still not clear as to the point that you're making about the tribunal's decision. I mean, either it had concluded that it had to be on a compensatory basis, or it didn't. The first sentence of paragraph 19 strongly suggests, to me at least, that the tribunal felt that it did have to be on a compensatory basis. But anyway, let's look at the Court of Appeal, what the Court of Appeal says. It may become
certainly
clear.
Well, hopefully that will push the quality of my argument along. Can we go to MS 225? Paragraphs 56 to 58. Again, you'll have seen this before, but this is the basis of the Court of Appeal's reasoning of why the tribunal was wrong. And they say in paragraph 56, Mr. Hoskins now accepts that there is nothing in section 47B of the Competition Act or in the rules which requires aggregate damages to be distributed on a compensatory basis of the kind envisaged by the tribunal, and that there was an error of law if the proper reading of paragraphs 87 to 89 of the judgment is that the tribunal considered that distribution must in all cases be carried out on some kind of compensatory basis, however approximate. Now let me clarify what I did and did not accept on behalf of Mastercard. Number one, I accepted that there is nothing in section 47B of the Act or in the rules which on its face requires aggregate damages to be distributed on a compensatory basis. I showed you the distribution provisions, and they're very short and they make no mention of compensation. I accepted that if the tribunal had proceeded on the basis that there was such a legal rule, then that would be an error of law because there wasn't such an error, a rule of law on the face of the legislation. But I did not accept that the tribunal had proceeded on that basis. And you can see that in the transcript. It's the second day in the Court of Appeal, MS 958. I wasn't planning to take you to it at the moment. It's from page 84, line 24 to page 86, line 11 of that transcript at MS 958. So the crucial question now for us is whether the tribunal did proceed on the basis that there was a requirement arising from the legislation that distribution must in all cases be compensatory. If you go back to paragraph 58 of the judgment, you'll see that the Court of Appeal held that that, in their view, was what the tribunal had done. And our submission is the Court of Appeal was wrong to adopt that interpretation of the tribunal judgment.
Just take me back to paragraph 19 of the tribunal's decision to refuse leave to appeal. Where is that again, please?
It's MS 233.
233. Tribunal held that the introduction of a collective proceedings regime has not changed the fundamental nature of damages for breach of competition law as being compensatory.
And that's right, my lord. And what that relates to is that certainly it's common ground between the parties, and indeed the tribunal took the position that an award of aggregate damages must indeed be compensatory to the class as a whole. Absolutely. What we are now dealing with is the question of distribution to the individual members of the class. And the question there is, to what extent is there a legal requirement that any distribution must have a relationship with compensation? And or to what extent, if there is not such a rule, can the tribunal nonetheless take account of the relationship to compensation as a relevant consideration when it exercises its power under the rules to approve a distribution model? Lord Legate.
Yes.
It's true that obviously the section 47B doesn't say anything about damages having to be distributed on a compensatory basis, but there could be an argument that the substantive law of tort requires you to get, by some means or other, to a rough attempt to compensate individuals for their loss, and that the collective proceedings regime provides a different way of doing that, but it doesn't displace that fundamental principle.
Well, I want to make it clear.
Am I right to understand that you do not advance that argument, and that you entirely put your case on a different basis, which is that there is no such fundamental requirement? In principle, that's not necessary.
My Lord, I actually do put both those arguments, and I put the argument based on the fundamental nature of tort in the alternative. So the first point I make is that the Court of Appeal was wrong to find that the tribunal found that there was a legal requirement in all cases that distribution should be compensatory. But we make the alternative argument in our written case that if we're wrong on that, and the tribunal did adopt such a rule, then such a rule was in fact appropriate and under the law. And I'll give you the reference.
A half-hearted way of putting it, but that's how you put it, is it?
It's purely because the way the argument came out in the Court of Appeal, my Lord. I don't shy away from either of the arguments, but they are simply alternatives. And the second alternative sort of follows from if we lose the first, then you get to the second. But I adopt both of them, and we have done in our written case. Let me just find the reference for you so you have it. So you can see it's been put. It's MS 135. And it's paragraph 118. So I think Lord Briggs has a question.
Thank you.
Sorry,
Mr. Hosking, am I wrong to see a rather large gulf fixed between Mr. Harris's concession recorded at the end of paragraph 19 in the PTA ruling, we're on 233, and what the tribunal then said was the applicant's failure? The concession seems to be that provided the group as a whole is properly compensated, then any distribution within the group that is fair will therefore whereas what the tribunal are saying is that no, if you can't come up with a method of distribution that isn't compensatory on an individual basis, then you lose, which seems to me to be something quite different.
Well, I think it's you need to be careful, I think, about taking the permission ruling, taking it out of context with what the tribunal found in its actual judgment, because it did refer to the concession of Mr. Harris in the judgment. The primary significance, I agree, my Lord, with the significance of Mr. Harris's concession is the timing of when you can look at a distribution methodology. He accepted that the tribunal could look at the proposed distribution methodology at the certification stage, but it's certainly not the case in the tribunal's judgment. Its finding on distribution was based solely on the concession. It wasn't a case in which there was a concession and the tribunal said, we don't need to consider the merits. It noted the concession and it considered the merits. So I understand precisely what you're saying, but the tribunal didn't put the weight in its judgment on the concession as being the sole reason for the conclusion it came to.
It's right, isn't it, that its conclusion was that if you look at it from the point of view of any individual member of the class, the level of his compensation treated as a share of the group award wouldn't be compensatory.
It would bear no relation to the compensatory principle, yes.
I mean, may there not be cases in which the awards are all sufficiently small and the difficulties in establishing a proper basis of discriminating between different members of the class are so great that actually the old equitable maxim that equality is equity has a common law reflection in this unusual context, that equal shares are fair and therefore a fair way of distributing a compensatory award.
That's where we got to, if you like, in the argument in front of the Court of Appeal, and that's the base I think the Court of Appeal was persuaded, was that there may be some cases in which you simply say, we're not going to even try for any degree of compensation. We are simply going to say the amount's too small, we'll just dole it out, you know, on some sort of arithmetic formula. The point was, in this case, that that's not the way the applicant suggested it should be approached. I've showed you his pleading. And the tribunal felt in a case of this nature that that was not an appropriate approach to go. The tribunal thought in a case such as this, there should be some reference to compensation. But the Court of Appeal overturned the tribunal because it said the tribunal was finding that in all cases, even the sort of example your lordship has given, there must be a relationship to compensation. And that's the very narrow point upon which the Court of Appeal overturned the tribunal's judgment.
Yes.
And my submissions on that point are as follows. There is nothing on the face of the tribunal's judgment that states expressly that the tribunal considered that as a matter of law, distribution must be carried out on some kind of compensatory basis in all cases. I've taken you to the tribunal's permission judgment in which it expressly stated that it proceeded on the basis there were no substantive legal requirements which a proposed distribution model must meet. I've made the point to you that tribunal's judgment must be understood in the context of the arguments that were put before it. And the applicant sought to justify its proposed distribution methodology on the basis that it reflected the compensatory principle. Be in no doubt, we're all singing the same hymn sheet. Should be as compensatory as possible. And therefore the tribunal was entitled to consider whether that was in fact the case. It was simply considering the case put to it by the applicant. And the issue of whether as a matter of law, as a legal rule, distribution must in all cases be carried out on some form of compensatory basis wasn't raised before the tribunal. And the tribunal cannot be taken to have decided an issue that was not before it. And that's why the particular reason why the Court of Appeal overturned the tribunal's finding, we submit is based on a misunderstanding and a misinterpretation of the tribunal's judgment. And that's why the Court of Appeal's judgment cannot stand. And that comes on to the related question of, well, was the approach actually adopted by the tribunal lawful? We say it clearly was. The statutory regime permits what would otherwise be individual tortious claims to be tried on a collective basis. The basic principle in tort is that damages are compensatory. Second point, Rule 92 of the tribunal rules doesn't establish any substantive principles by which the tribunal is to determine the amount of distribution to individual members of the class, and it quite clearly on its face does not preclude reference by the tribunal to the compensatory principle. The third point is that under section 47C sub 2 of the Competition Act, the tribunal may make an award of damages without undertaking an assessment of the amount of damages recoverable in respect of the claim of each represented person, and that's the aggregated damages definition. However, in this case, the tribunal did not hold that any proposed distribution mechanism must result in exact compensation for each member of the class, nor did the tribunal hold that the distribution methodology must be based on a detailed assessment of individual losses of each class members. The tribunal expressly recognized at paragraph 88 of its judgment, that's MS 269, that distribution, and I'm quoting, will often be imprecise and may have to be based on broad estimates. So that's paragraph 88 that we saw earlier and I asked you to read. And the problem in this case, as far as the tribunal was concerned, was that the distribution methodology proposed by the applicant bore no relationship at all to the compensatory principle, and its own experts accepted that that was the position, and that the applicant had failed to satisfy, therefore, the tribunal that the distribution could be determined on any reasonable basis. And we say the tribunal was perfectly entitled under the legislation to have regard to the degree of relationship to compensation as a relevant consideration, even if it was not a legal requirement as such, but it was clearly a relevant consideration that it had regard to. And therefore, we submit that the tribunal's conclusion on distribution was entirely in accordance with, again, the legislative framework. There was simply no error of law.
Yes.
Sorry, Lord Sales has a question.
Yes, Lord Sales.
I want to check I've understood where this fits in the statutory scheme. Are you saying that this question of distribution, the method of distribution, comes into the question of suitability, that it's a factor relevant to whether it is a case suitable for making a CPO, or how exactly does it come in?
I do, absolutely do. That's the way I put it. And you see that at MS 269, paragraph 89 of the Tribunal's own judgment.
Yes, thank you.
And you'll bear in mind that under Rule 79, the Tribunal may take account of all matters it thinks fit in determining whether a matter is suitable or not. So clearly, having regard to this matter was something that was within the scope of Tribunal's discretion in Rule 79. The final point I have to deal with is the second basis upon which the Court of Appeal overturned the Tribunal's finding on the distribution issue, because actually it had two reasons. The first one we've just dealt with. We're moving to the second one. And the second point one can see at MS 226 in the Court of Appeal judgment, paragraph 62. So we've seen the earlier part of the judgment where it discusses this reference to the compensatory principle. And then if I'd ask you just refresh your memory on paragraph 62, please. So this was a separate and distinct reason for overturning the Tribunal's judgment. And the Court of Appeal held it was premature and wrong for the Tribunal to have refused certification by reference to the proposed method of distribution. Distribution is a matter for the trial judge to consider following the making of an aggregate award of damages. Now, in our submission, the Court of Appeal itself was wrong to find that the Tribunal was not permitted as a matter of law to consider distribution at the certification stage. In our submission, distribution or proposed distribution was again a relevant consideration that the legislation permitted the Tribunal to take into account at the certification stage. And this echoes the point that Lord Sales just put to me. Rule 79 sub 2 of the Tribunal rules provides that in determining whether claims are suitable to be brought in collective proceedings, the Tribunal shall take into account all matters it thinks fit. Second point, there is no legal bar in the Act or the Tribunal rules which prevents the Tribunal from considering distribution at the CPO stage. The third point is there isn't in fact any legal bar in the Act or Tribunal rules that would prevent the Tribunal considering submissions by a defendant after the award of aggregate damages. And I showed you the language of paragraph 6.83 of the Tribunal Guide at MS 1172, where the guide says, typically, the defendant will not be involved in the process of determining how the award is to be distributed amongst the class. But there is no absolute exclusion of a defendant from making submissions in relation to distribution at any stage of the proceedings. Fourth point.
In what way should the Tribunal, or may the Tribunal, take into account the proposals for distribution?
Well, what I'd say is this, my lord, is that putting it in the context of this case, before granting a CPO for a claim in excess of £14 billion, because that's the total of the claim, we submit it was reasonable, again I'm using the error of law language, it was entirely reasonable for the tribunal to consider the applicant's proposals for how any aggregate award of damages would be distributed to class members. And you've seen the nature of that proposal. It was simply split up the award into each year and then just divvy it out on a per head basis, regardless of the actual loss that each member of the class had suffered. It was arbitrary in that sense. And where, again, an applicant comes with such a broad claim, such a large claim, and says, I want you to make an award of damages for £14 billion, it's entirely reasonable for the tribunal to say, well, that's very well, but if we do give you a substantial award, what are you going to do with the money? And that's what happened in this case. And the applicant put forward only one proposal. The tribunal said, I'm sorry, that is so divorced from the principle of compensation that we think that your proposal as a whole is not suitable for certification. You have to look at where this is headed and not just simply at what's in the paper in the application.
So the tribunal was saying then, was it, that because this is, well, random is the wrong way of putting it, but this is a mechanical way of splitting up the compensation which you seek, and because it doesn't investigate the individual loss to particular cardholders, that it's not acceptable.
I think that's in essence what it was saying. It's not that the tribunal was saying you must come up with a distribution mechanism that investigates at any level, at great level of detail, the award to the individual members. The stumbling block here was a more simple one, and you see it at MS 268, the last sentence of paragraph 85. It's the way the applicant himself expressed his methodology. His two experts agreed that their proposed method bore no relationship at all to the individual loss. It's not even on a sliding scale, well, how much is it? How much do you need to investigate? When the experts were asked, they said, yeah, this has no relationship at all to compensation. It's simply not about compensation. And then one sees that evidence from the experts.
It is about compensation. I mean, you're getting money if the claim succeeds, but it may be that it doesn't reflect your actual loss.
Yes, sorry, I mean, but I'm using compensation as shorthand for the compensatory principle in tort, which is, as you know, that a victim must be put in the position he would have been if the tort had not occurred. So I'm not using compensation in the sense of do they get some money? I'm using compensation in the sense of does the money it is intended they will get bear any relationship to the loss they have suffered in accordance with that tortious principle?
Well, if I've understood your submission correctly, you are saying that the applicant for the CPO didn't have to show that they had investigated each individual's actual loss. Now, if that is right, how do they set about computing the loss so as to adhere to the principle that the tribunal defined?
Well, the burden of proof, remember, is on the applicant. Because one starts with the question of whether such a broad scope of application should go forward. Because most, and we've seen in all the applications for collective orders that have followed, they're much narrower than this. The problem with this application is its breadth, and that's what raises the real issues about whether it is practical or not.
Yes, but you did say, yeah, I'm sorry, you did say,
sorry.
You did say, if I understood you correctly, that it wasn't incumbent on the applicant to come up with a system whereby each individual loss would be computed. Well,
That's correct.
Well, if that's right, how do you say that the applicant could have satisfied the requirement that, that there be a relationship to the individual loss?
Well, there are. It's not for me because I'm the defendant. The onus, the obligation under the legislation was on the applicant. Now, for example,
I've got that point, but I'm not asking you. How do you
I'm trying to answer, my lord. I'm trying to answer, I promise.
Yeah.
Can we go to MS 268, please?
Yes.
Because Professor Mayer was one of the members of the tribunal, and he put a suggestion to the applicant's experts and said, well, what about this as an approach? And asked them whether that would suffice. Now, that's an example of an expert, albeit the one sitting in the tribunal, addressing his mind to the question of whether, without having to compute the individual levels of loss, there were in fact means of coming up with some sort of process that at least bore some relationship to the compensatory principle. But the problem for the applicant was that the experts were not keen on that suggestion. They hadn't considered it. And as I've shown you, the applicant's position before the tribunal was only to say, this is the only methodology we are prepared to put forward to you. We are saying to you that the only methodology that we think is appropriate and practicable is our per capita distribution. And the point I make in response to your question, my lord, which is a very fair one, obviously, is there are potentially means by which experts could come up with something which is not as blunt as the applicant did. But my point is it is for the applicant to do that exercise, not for the defendant and not for the tribunal. Tribunal can only deal with the evidence, the arguments that's put before it. And that's the way I'd respond to that question.
Right. Okay, let's move on then.
Well, the final point just simply on this timing issue, which is the specific point of whether the tribunal is entitled even to consider a proposal for distribution at the certification stage, is the concession that was made by the applicants, by Mr. Merrick's own counsel. And if you go to MS 254, it's the point that Lord Briggs asked me about earlier. Mr. Harris very properly accepted that if it appeared at the outset that there is no methodology which can produce a fair distribution of an aggregate award of damages and therefore proper compensation, then that is a matter which the tribunal can take into account in deciding whether to grant a CPO. And that's I hope that sort of helps clarify the response I gave to Lord Briggs, that what this is really directed to is the timing issue. Was it open to the tribunal to consider the proposed distribution methodology at the certification stage at all? The Court of Appeal held that it was not, but as I've shown you, as a matter of law, it was open to the tribunal to do so, and indeed the applicant's own counsel agreed that it was open to the tribunal to do so before the tribunal. My lord, I'm happy to say that very slightly under my allotted time, those are the submissions I wish to make, unless the court has any further questions that they have for me at the moment.
Thank you very much.
Thank you.
Mr. Cook, Mr. Keith, or Mr. Lawrence wish to follow?
I don't think they're actually on this. Saying that, I presume they don't wish to follow, my lord. I hope that's right.
Thank you very much indeed. Right, Mr. Harris, then. Thank you.
Good afternoon, my lords.
Good afternoon.
May I begin by thanking the court for the indulgence of sitting early both today and tomorrow to accommodate other commitments.
No, not at all. I'm sorry that we had to change the time, but I hope I've explained why that was so.
Yes, I am grateful. I shall be addressing you on ground one, and then Mr. Dimitriou tomorrow morning will be addressing you in response to Mr. Hoskins' submissions on ground two about distribution. And I had intended to begin with a few opening remarks, setting the scene by reference to the purpose of the legislation and the certification requirements. But in fact, in light of the exchanges that have been going on with Mr. Hoskins today. I'm going to dive straight into what Lord Thomas described earlier on as the nub of the case on ground one. What is the ... if I can borrow that phraseology? What does it mean to say some evidence of the availability of data within the meaning of the last sentence of paragraph 118 of Process versus Microsoft, which is the test that the tribunal said that it was applying and which everybody agrees is the correct test? What does that mean? It means that in a case such as this, which is an aggregate damages case, where we're trying to assess how much is being passed on to the indirect purchaser level, so to the consumers, some evidence means not no evidence. So that's the first point. Some evidence means not a wholesale absence of evidence. And what does that some evidence of availability of that data have to show? The test is very clear, and I will show you in due course where this is set out. It has to show that there has been some degree of pass on to the indirect purchaser level. So in summary then, the ... some evidence means not no evidence at all. What does that evidence have to go to? It has to go to show that there has been some pass on of some loss to the indirect purchaser level. What does it not mean? It does not mean, one, that you have to show at the certification stage that all the loss has been passed on. Nor do you have to show that the loss has been passed on for the entire time of the claim. And indeed, as we shall see in the Canadian exposition of the test, thirdly, you do not have to show at the certification stage that has been passed on to all members of the class. I will obviously take you to process in more detail, but those are the two things that you do have to have. Some evidence, not no evidence, or pass on to the indirect level, and what the three things that you do not need to have, not for all of the loss, or for all of the period, or for all of the members. And taking a step back, why? Why is this the right test? The answer is straightforward, because in an indirect purchaser aggregate damages claim, it advances the litigation to find out whether any loss has been passed on to that level. What I mean by that is the following. If it turns out that some loss has been passed on to that level, then that is a common issue, because it's the class consists of all the people at that level. And it therefore follows that you have resolved in common for those members of the class that issue. And you therefore do not have either a duplication of fact-finding or legal conclusions, or a waste of judicial, or for that matter, litigant resource. Because it is common, you're determining it collectively. It advances the litigation. Lord Legate.
I can understand that in the context of the Canadian cases, where they were concerned with whether there's a common issue. And they said the common issue is whether there's been any loss at all that's been passed on, and that's what needs to be shown. But that's not the question we're concerned with. We're concerned with the suitability of aggregate damages, and that's what we need to focus on, isn't it? Which is different from what the Canadian cases are looking at. Or when they are, they're looking at a different part of the judgment from the one that we've been shown.
Well, with respect, Lord Legate, no, we don't agree. The key consideration in an aggregate damages case as to whether it's suitable or appropriate, sensible, if you like, to proceed collectively is whether that issue of loss is common. That's the key consideration. And I say again, the reason for that is if it is common, then it makes sense, it's suitable for it to proceed collectively because it avoids a duplication of fact-finding or legal conclusions and a waste of judicial resource. And what we'll see is these rationales emerge. Lord Sales, I'll be with you in just one moment, if I may. These rationales emerge clearly underpinning the Canadian case law. So I rely upon the reasoning. Lord Sales.
Yes, I rather question whether it is necessarily the primary question, whether the loss is a derivative of a common issue. Isn't it also going to be relevant whether there can be a trial which can be regarded as fair or just in relation to the extent of that pass through? Now, you pitch unsurprisingly, the standard of some evidence pretty low, but even on your test where you said some evidence is not no evidence, I mean, part of the case that's put against you is that for very large sectors of the entirety of our economy, there isn't evidence of there being suitable evidence at all from which inferences could be drawn. So might it not be said that the dissonance between the underlying objective to give people compensation for what they've lost, at least in a broad sense, and the ability to have an acceptable way of assessing what that loss is, just becomes so great that it can't fairly, or at some lesser standard, be tried in using the methodology that you have proposed?
Well, that goes to, of course, the heart of the issue is quite exactly how much evidence one has to have across all of the sectors for all of the time. And what I respectfully say is that when one is asking oneself the question of, is it suitable to do it collectively, as opposed to, in this case, potentially 46.2 million trials, all raising potentially the same issues, then a very key consideration is whether or not, in fact, those are common issues in the sense of being same, similar, or related. And if it's right, I beg your pardon, if it's right, and then I'll come back to you, if I may. I'm sorry, it's a bit difficult with the videos. But if that's right, that it's common, which is, in my respectful submission, why the Canadian case law focuses upon that, then that weighs very heavily in favour of doing it collectively as opposed to in any other form. And I choose that word very carefully. Form is thematic of the Canadian rationale. But I do take your point, Lord Sales, that it could be the case that you could also, in theory, have a more onerous evidentiary standard. But my respectful response to that, that's not what happens. That's not, and I can show this very clearly, what happens in Process versus Microsoft, which is the test that everyone said that they were applying. But let's assume we weren't applying that test, we were applying some other test. Then you could ask for more evidence. But my respectful response to that is that that's not suitable at this preliminary stage, pre-disclosure, before even pleadings have been concluded. The answer to that is to say that, consistent with the express power to be found in Rule 85 and Rule 91, then either once it becomes clear later down the line that there genuinely is, for example, no evidence in a certain sector or for a certain year, then you amend the class or you create a subclass or indeed you decertify. But the problem at this very preliminary stage, pre-disclosure and pleadings, in asking for something that is more than what the Canadian cases call not onerous, is that that's not then consistent with the underlying rationale of the legislation.
But why isn't part of the underlying rationale of the legislation not that there should be some threshold condition before one plunges forward with a massive and very burdensome claim, so that the tribunal can have some assurance that if it does give the go-ahead to a claim of this kind, it's going to serve a useful purpose, not entirely divorced from the just resolution of the issues between the parties at the end of the day?
Well, because what I say again to that, this is not a threshold test without teeth. This requirement that there be some evidence as opposed to no evidence of showing loss onto the indirect purchaser level has been seen to knock out several cases that are in the Canadian courts. So that I'm just using them examples. I take Mr. Hoskins' point about not putting undue reliance upon particular fact patterns in other cases. But what they show, and these are the cases of Chadha in the Ontario Supreme Court and Kirk in the BC Court of Appeal, what they show is if you show up at certification and you have literally no evidence on a particular point, then you don't proceed. And in the case of Kirk, this is one of the cases that my learned friend put in, Mr. Kirk, as the proposed representative, showed up with no evidence at all on punitive damages, and he was denied. It also shows that if you arrive at the tribunal at the screening stage, and what you don't have is any data at all to be applied to your methodology, then you don't proceed. So, for example, in the same case, Kirk, diminution in property values, it was denied. He couldn't go ahead. It knocked that out. And what you also have, let's not forget that although we focus, for understandable reasons, in this particular appeal on the last sentence of 118 of process that talks about some evidence of the availability of data, in fact, our submission is that, as in Canada, it's all part and parcel of the, quote, some basis in fact test. That's what it says in the first line of 118, and that's drawn from the Supreme Court case of Hollick. And the other part of that is, have you got a, quote, credible or plausible methodology, unquote, and is that, quote, purely theoretical or hypothetical? And that is not this case. And what my submission is, that when you have a case where it is common ground that you have a credible or plausible methodology that is not purely theoretical or hypothetical, which is this case, that's what the tribunal found and it's not challenged, then the requirement for evidence is even less substantial.
One last question, just to finish my train of thought. I can understand, and indeed the common law makes it clear that it's the correct way to proceed, that one can fill in some gaps in evidence. So my Lord Briggs gave the example of rent adjustment clauses and things like that, where one has a data series of rent adjustments or something like that. There may be a gap in that series, but you can draw inferences and leap across that gap by drawing inferences. But speaking for myself at the moment, I would welcome assistance from you in due course as to how that could work in relation to the data sets that your experts' methodology would require to be used here. Because as Mr. Hoskins has emphasized, we only have partial data sets potentially for the retail and I think petrol sectors, but that leaves huge sectors of the economy where it seems that there is a dearth of data available at the moment, and your experts didn't give an indication of how that data gap could be plugged. And I'm struggling for the moment to see how that would be the sort of case where you could draw inferences, for instance, for what happened in the retail sector to plug those gaps, simply because the retail market will obviously be very, very different, potentially, from a whole range of those other sectors. So in due course, if you could help me with that at any rate. I'll stop asking questions now, because I don't want to take up too much time.
Let me give you a thumbnail answer and I'll revert further in the morning. The first one is, you're quite right that in expert cases, methodological and econometric cases of this kind, one does engage in drawing across from one data set to another, call it extrapolating or inferencing or whatever you like. And Lord Briggs, and insofar as inherent in your question, are perfectly right. And no doubt that would happen. But perhaps the more important thumbnail answer is that we approached this case at the CPO stage on the basis that of the Microsoft test, which was said to apply, which is very, very clear in only needing to show some evidence of availability of some loss to the indirect purchaser level. And therefore, that's what we did. And that seems to be wholly now without dispute It seems to be totally accepted that we had some evidence of the availability of some data to the indirect purchaser level, albeit that Mr. Hoskins now says it's only petrol and supermarkets. But you will have picked up, and I think this may have been Lord Legat, and I believe it may have been, I'll find the paragraph number in the tribunal judgment, but where they say it is beyond doubt that, and I paraphrase, some of these sectors have been studied in detail. So if and insofar as I am right about the test, then in my respectful submission, we have plainly met the test. And the second part of that thumbnail answer, Lord Sales, is this, that we say it's wrong in principle and inconsistent with the scheme of the legislation for the experts to be expected to arrive at the CPO hearing with more than some evidence of some pass on to the indirect purchaser level when it is pre-disclosure. And when it costs a great deal of money to put on a CPO full stop, let alone if there then has to be masses and masses of expert data upon the expert evidence upon the availability of data. That's not how it's been pursued in the under the Microsoft test. So I'm happy to revert again tomorrow, but that's the thumbnail answer to what I say. And it's no accident in this regard that the guide does not say anywhere that the experts have to show up with an expert report at all. Right? So there's not even a requirement for an expert report, but it certainly doesn't say that as part of the expert report, the experts have to come with a full list of the availability of data for all of their sectors for their whole time to all of their class members. It simply doesn't say that. And that's consistent with what we say is the proper interpretation of the Microsoft test at 118. So with that, and just finishing off then, again on the nub of the question, it's because we say that the Microsoft test, which everybody said was the right test to apply, has been misunderstood and applied too stringently, that we say that that's the error of law. And the Court of Appeal agreed. What it said, in essence, was you've overlooked the fact that all that the claimant, the proposed representative claimants, experts needed to do was show up some evidence of the availability of data for pass on to that level. You've overlooked that or misunderstood it. And you've asked for more than that. You've asked for all sectors for all time for the whole period. And then, as regards the some evidence that has been put forward, you've subjected it to an unduly rigorous standard of scrutiny, both in your questioning and in your criticisms of it. And to just paraphrase that, and I'll come to you, Lord Legat, if I may, just to paraphrase that or to summarize that, those are effectively criticisms of what the Court of Appeal called the, quote, probative value, unquote, of that some evidence. And that's not consistent with the test. Lord Legat.
Evidence of.
I beg your pardon, I missed.
Sorry.
I beg your pardon.
It does seem to me that the critical question is what you need to have some evidence of. If all you need to have some evidence of is some pass-through to the consumer level, well then the tribunal didn't ask itself the right question and it patiently had it. But if the proper approach is that you have put forward a juggernaut of a claim which seeks to recover aggregate damages across the whole economy, and you have to show some prospect that there will be data that will support such a claim, then it seems to me at the moment that the tribunal was entitled to find that it hadn't shown there was any realistic prospect of showing that. So I would say it seems it's critical to identify what the correct question is.
I completely agree, Lord Legat, and the correct question is, what is the test that the tribunal said it was applying? What really is that test? Answer, the test expressly that it said it was applying was the one at 118 of Microsoft. Secondly, every single person agreed with that. And thirdly, today, every single person agrees with that. Therefore, we have to address our minds to what exactly is that test? And I will show you that it is beyond argument that it means what I say. It means some evidence as opposed to none, and it means pass on of some degree to that level of the chain, and everything else goes on to the trial or run up to trial case management after there has been closure of pleadings and disclosure. And that is, with respect, we say to Mastercard, utterly beyond argument on the true reading of Microsoft and the associated cases. And since that's not appealed, it's not appealed and said, oh, you shouldn't now be applying the process Microsoft test. On the contrary, it's always been common ground that we should apply the process Microsoft test. And I will develop that because it's no accident, although I'm prefacing myself here. I'm now going to revert to where I would have. No accident that when you read the Court of Appeal judgment, they begin by setting out from paragraphs 102 up to 118 of Microsoft, and that's in the Court of Appeal judgment MS 219. I don't want to turn this up right now. Just giving you the note. They cite 118, and then they go back on page 220 of MS 220 to cite paragraphs 102, 103, 104, 110, 111, and 115 of Microsoft. And when those are all read, it is completely clear that what I've described as being the test is what they understood and understand to be the test, including with reasons why it's the test. So I'm going to develop that obviously in more detail in due course. And may I, unless there are any other questions now, while I hope I'm addressing the real nub of the matter, at least in outline, I propose very briefly to address you on the purposes of the regime and the purposes of certification as the first two topics. But this will be rather quick, if I may.
Yes. I'm
grateful. So if you wanted the page reference, though I don't propose to turn it up, there is a government consultation paper by BIS at MS 2629. And what it says under the heading, why is reform needed? So this is before the Consumer Rights Act 2015. The reasons why there needed to be a change of regime so as to allow class actions of the type that I propose to bring, if given permission, to go ahead. It gave a number of reasons. It said that there needs to be better, and I quote, access to justice, because the previous regime was, and I quote, difficult and expensive. And it goes on in para 3.13 to say that where there are large claims that are difficult and expensive to bring, but only small per capita recovery, it makes, and I quote, no economic sense, unquote, to pursue them except in the way of a collective. And our case, of course, is a paradigm example of exactly those 2 points. Access to justice, difficult and expensive case that would bring a relatively small per capita, though large in aggregate award. It is in fact common ground that if we do not proceed with these proposed class members, the ones that I describe as victims of this proven infringement, do not proceed collectively, then they will not proceed at all. It is no accident that there are no individual claims seeking the loss that I seek to claim in aggregate. Put another way, it is no accident that great big companies like Sainsbury's and Morrison's and et cetera, they can do it for their potentially hundreds of millions of pounds worth of loss, but the individuals simply can't do it, and the proof is in the pudding. It's what Lord Justice Patten described in his judgment for the Court of Appeal as the end of the road. If there's not permission to pursue this. I don't say that in terrorem, but I say that because this case is an example of needing to have a collective action to allow access to justice in these difficult cases. And it goes on in this rule sales.
I want to ask, you say it's the end of the road, but wouldn't it be possible, if there is merit in the appellant's appeal ground 1, for you to find some sector of the economy where you could meet the standard of data that the CAT saw propose, and just confine your case to that one, but on a collective basis?
It is potentially possible to have a smaller claim or a smaller subclass To that extent, I agree with you. But the very next, there are funding implications to which Mr. Hoskins adverted. And in this case, as it happens, there are limitation issues. But one of the points that the Biz paper goes on to make is that you have to have a fund created to deliver redress to the claimants. And there is an obvious implication by the size of the claim for the amount and type of the funding. But my other answer to that part of that question, Lord Sales, is that the proper time to assess that in my submission is once there has in fact been a closure of pleadings and there's been disclosure, because as I will show you in due course, Mastercard itself submitted, and indeed you adverted to this with my learned friend Mr. Hoskins in the context of his submissions in January in the other Mastercard case. Mastercard itself submitted in the retailer actions in Sainsbury's that there was, and I quote, and I will show you this. In fact, I'll show you now. This is MS page 330. If I could turn you up, if I could ask you to MS 330. This is in the middle of our CPO written application at paragraph 107. Under the heading, this is on 329 of pass on to consumers via higher prices. And then we list various things. I'll be coming back to these later. But the one I just want to draw to your attention now is E. So in that Sainsbury's case, the proposed defendants, that's Mastercard, argued and presented evidence that accepted economic theory indicates that there will have been pass on between 50 and 100% in the present case. And then this is their expert under a statement of truth bound by CPR 35. There is overwhelming factual evidence that pass on by Sainsbury's will have been at the high end of this scale, closer to 100% and 50%, as recorded in paragraph 466 of the judgment. Then it says footnote 79. And if you go to that footnote, it cites the expert report of Mastercard's expert in 2015. And he says, said, based on these analyses, I conclude that there is a strong economic presumption. And then he goes on, my findings are consistent with Mr. Harmon's assessment. And then he goes on, based on my economic analysis of the available evidence and data. So this is my learned friend's own expert saying that there is overwhelming factual evidence in one case, and that it's based on analyses, and it's based on findings from the market consistent with the other side's expert, and that he's basing his analysis on available evidence and data. And yet we don't have any of that. This is all in the hands of Mastercard. We don't have any of that. And I'll just address briefly now my learned friend's point that he was at pains to make. I noted it down 3 times, which was that supposedly the evidential value of this stuff that we don't have, it's not being provided to us, is of limited or no value because Sainsbury's actually lost in that case. Well, the first point of principle is we're not assessing here whether I'm going to win or I'm going to lose. So that's an irrelevant response from my friend. It's not addressing the merits, we're addressing the question of form. But more importantly than that, what my learned friend hasn't drawn to your attention, which is to be found on MS 2021. And I would like you to turn this up briefly, please, because otherwise there's a danger you will never see it. It's the Sainsbury's tribunal judgment. So the one to which you were 3 times as showing that Sainsbury's didn't succeed on the merits on its facts with its evidence. The very same judgment says at paragraph 5251 at the top of page 2, MS 2021, and I quote, prima facie, Sainsbury's would have sought to pass on the cost of its UK myth onto its customers. Although Sainsbury's would not have been unconstrained in its ability to pass this cost on, because the UK myth was a cost common to Sainsbury's and its supermarket rivals, we consider that a substantial amount of the UK myth, 50%, would have been passed on, albeit not in a manner which would have amounted to a defence of pass on for the reasons given above. And that was is a very detailed legal debate about precisely what it means to run it as a defence. But on the facts, this tribunal did conclude that there was substantial amount of UK myth passed on, 50%. So my response, Lord Sales, is that it wouldn't be fair to judge the proposed claimant in this case, representative claimant in this case, including by reference to the fact that there is obviously considerably more data or, quote, overwhelming factual evidence, unquote, that resides in the hands of Mastercard that we haven't been provided with. And they are fighting, as I understand and what our evidence says, across many, many sectors. It's not just supermarkets. There are hotel chains, there are rental car companies, there are all manner of things. And very great detail is provided in that in our 2 expert reports. I'm not going to turn it up, but the original expert report provided a lot of detail about, I think it said the then existing retailers covered approximately 70% of the sectors. And then since the date of that CPO hearing, there have been some 70 odd more claims that have been issued against Mastercard at the retailer merchant level, and therefore that have generated yet further evidence that I haven't seen. And so, would you just bear with me for just one moment? I've got a reference that I just want to check. Yes, so that what I was struggling for, if you wanted the detail of that, is to be found in our written case, the detail at MS page 172, at paragraph 51C. So as at the date of the CPO hearing, there were some 400 merchants progressing actions through the courts. And what we've been able to ascertain since then is that at least 70 further claimants of advanced claims. Footnote 65 refer to the subsectors concerned representing approximately 87% of card expenditures, which is even higher than I said a moment ago. And then the other point I'd just like to show you in this regard is that and I think, Lord Sales, you picked this up with Mr. Hoskins, which is the VAT point. You will have seen, and I'm going to go back briefly tomorrow to the recitation of the, quote, some evidence, unquote, that we did have back at the CPO hearing in 2017. And you will have seen that some of it was pass-on studies for analogous turnover taxes, such as VAT. And that is exactly the sort of material that was relied upon by Mastercard's own experts. So I don't know if you've turned it down by now, but if you either haven't or you can turn it up, it's MS330. Yes. And what the learned expert on behalf of Mastercard agreed with our expert, because he said, we quoted here, given that they were viewed and treated very much like a goods tax, such as VAT. This is a different expert, by the way. The footnote is 80, so more than one expert. They're effectively a common cost which is passed on to all customers in prices. Well, that is precisely what Dr. Velenovsky said in section 6 of the expert report that was before the tribunal in this case. So there is a complete convergence of economic and theoretical approach by reference to these principles. And on top of that's why the tribunal, inter alia, why the tribunal did conclude, and with respect was forced to conclude, that we had a methodologically sound methodology for proceeding. So that's, if you like, the first part of paragraph 118 of Process and Microsoft. And then what we had in addition to that, pre-disclosure, was at least some evidence of the availability of data for applying that in different sectors across the economy. But the experts were very clear, and the Court of Appeal picks up on this repeatedly. The experts were very clear in saying, we don't have all of it. We're waiting. Some of it we might get from Mastercard, some of it we might get from third parties, some of it are public studies. Dr. Velenovsky also said, and if you'd like to see the CPA, the transcript reference, what he also said is that some of this evidence has the habit, in his great experience, of emerging the more that you conduct your inquiries in the disclosure phase. So I will just show you that, because otherwise you will never see it. It's at MS 731. This is an extract from the transcript of the CPO hearing day 2. Now pick it up 10 lines down, Dr. Velenovsky. So he was our economic expert on behalf of Mr. Merricks. And what he says is, he's being quizzed here about the nature of the data availability. And then he says, well, correct. As to the data, I mean, in one sense, compared to a lot of other sectors, card expenditure is a very data-rich sector because it is a transactional thing. This is his expert evidence. And then he goes on, we're not talking about buying kits or something. So, I mean, I'm picking it up now at 13. If you look at the financial services, if I had to interpolate the data, I see that when the split comes out, we can make an estimate. But my suspicion, having worked a lot on these cases, is the more you delve into it, the more data starts to appear. Well, we're not at the delving in stage. This is disclosure. He even gives an example about a former client of his, which I won't read out loud. And then just a few pages further on, he gives you, now I could show you his CV, but it's at the back of the first expert report, and it's very enviable and very experienced CV. But I'm now on page 735, MS 735.
Sorry, Mr. Harris, I'm so sorry. Just before we move on from Dr. Velenovsky, I think perhaps one needs to be a little bit careful what data he's talking about, because what he's saying is data rich, as I understand it, is the volume of commerce data. And that will be true because you'll have lots and lots of records from Mastercard showing how much money has been spent on things. I'm not sure that he's addressing there the critical issue for us, which is data on levels of pass-through.
My lord, you are right in part that that particular sentence, the data rich, was about transactional data for things like overcharge and volume of commerce. But what he also gives is very clear evidence that he believes that he can apply his methodology to demonstrate, pass on to the indirect purchaser level. And indeed, a very good way of just demonstrating that point is to take one line from his expert report, which is if you just bear with me one moment, I do apologize. It's gotten I've got the supplemental one here, which is not what I want. The original expert report, yeah, tab bundle 2, got it here. Yeah, so it starts at MS 512. And I'd just like to show you again the sentence in para 6.1.1 on MS 542. At the end of that paragraph, 6.1.1, he says, we see no credible basis for the assertion that the MSC was not passed on to consumers within the proposed class across the United Kingdom during what is a full infringement period. So he has a very clear and indeed pretty forthright view that he will be able to apply this methodology, which is a sound, credible and plausible one, and that he will do it by reference to further materials that will have to be obtained, but that haven't yet been obtained. So only some have so far been obtained, to be found at 6.2.3. And then over the following pages. So we're not pretending in any way, shape or form that there had been an exhaustive survey and then a list at the date of this CPO hearing of every single potential available source of data that there might be across each sector for each year. We're not saying that that's what happened, because nobody thought that that's what needed to happen, because we were all applying the Microsoft test at paragraph 118 that doesn't require that. What you do know, however, is that it's common ground in light of the proposed introduction of the supplementary expert report that Dr. Velenovsky and Mr. Dearman have put together, that had it been the case that at any stage somebody had said, oh no, you have to list out much more than that, or the guide had said that, or indeed Process and Microsoft had said that, then we could have done it. We have now done it in the supplementary expert report. But that's not what anybody thought needed to happen at this stage, because that is very clearly not what Microsoft says. So just, I'll put that to one side, getting myself a little tangled up because I still use hard copy bundles, for which apologies.
As I said to Mr. Hoskins, it's not too late to convert, Mr. Hyde.
The problem, my lord, as you'll appreciate, is that it's a question of marking up the bundle as one goes along. That I have mastered. I've mastered it down.
It's entirely possible electronically.
Blimey. I'm sorry.
Old men like me can convert. A young chap like you can certainly do it.
Well, I will redouble my efforts. I'm grateful, Lord Carr. So in terms of the purposes of the legislation, I'm just going to finish off that section very briefly by taking you to the case of Holick. So I'll turn that up in just 1 minute. It's a Supreme Court case in Canada. I will, of course, tomorrow address you on why we should be paying regard to Canadian cases, why in principle. But for now, I'm just going to take you to one or two. So I had said before attempting to deal with the questions put to me that the purposes included access to justice, avoiding duplication, including of legal resource, and making available cases that otherwise couldn't proceed. And we will see that this is the same rationale that underlies the process test. And if you were to turn to the Supreme Court case of Holick versus the City of Toronto at MS 2191, I can make good this point very briefly. So that's 2191 is where it starts, and I'd like to take you to paragraph 15. This is the Chief Justice's judgment, and in her judgment, she says, having referred to, in this case, the Ontarian Class Proceedings Act at 15, the Act reflects an increasing recognition of the important advantage that class action offers as a procedural tool. I beg your pardon, paragraph 15 is at MS 2206. Refers to an earlier case in which she gave the judgment. It says class actions provide three important advantages over a multiplicity of individual suits. And I've just paused. That is a key question at the certification stage. Should I be doing this collectively, or should I be doing it by way of a multiplicity of other actions? And she says, first, by aggregating similar individual actions, class actions serve judicial economy by avoiding unnecessary duplication in fact-finding and legal analysis. Well, that's exactly what our Act, or the amendments to our Act, do, number one. So we share that rationale and purpose. Second, she says, by distributing fixed litigation costs amongst a large number of class members, class actions improve access to justice by making economical the prosecution of claims that any one class member would find too costly to prosecute. Well, exactly. So we share that rationale. That's this case and our legislation. And third, class actions serve efficiency and justice by ensuring that actual and potential wrongdoers modify their behaviour to take full account of the harm they are causing. And then skipping to the end of the paragraph, in my view, it is essential, therefore, that the courts not take an overly restrictive approach to the legislation, but rather interpret the Act in a way that gives full effect to the benefits foreseen by the drafters. Well, we've seen what benefits are foreseen in our legislation, and they are identical to these. And for the same reasons, I would urge upon you my respectful submission that we should also not take an overly restrictive approach to the legislation. It should be given a purposive approach so as to give effect to them. And then she goes 16, this is 2207, to say it is particularly important to keep this principle in mind at the certification stage. And one can well see why. The certification stage involves all manner of hurdles. Mr. Hoskins wrongly submitted to you earlier that the CPO hearing largely focused upon this question of the availability of data, but that's not right. My expert report and my CPO application had to cover every single one of these new requirements at quite considerable expense, not knowing exactly how they would be interpreted. Lord Sales.
Yes, Lord Sales.
I quite see the importance of all the points that the Chief Justice makes here, but doesn't one have to bear in mind, at least in the background, whether the claim can be tried justly by reference to the materials that are being put forward? I mean, it's really going back to the point I was putting to you before about a level of dissonance between broad procedures and whether you're going to achieve justice at the end of the day. And I just want to mention something to you that you can think about overnight, not looking for an answer now. If you go to the tribunal rules, Rule 2.2 says that the rules are to be interpreted in accordance with the general principles which are set out in Rule 4. And Rule 4 is, to summarise, essentially the overriding objective that claims be tried justly and proportionately at proportionate cost. It's a repeat, if you like, of what I put to you before. Doesn't there get to be a problem if the dissonance between what you're going to achieve by using these processes and just outcomes becomes just too great, that it isn't appropriate to proceed, even though you would get some benefits in terms of what the Chief Justice has referred to here?
Yes, and the answer in a nutshell to that question, my lord, is as follows: that if after you've had disclosure and pleadings, it transpires that it becomes obvious, even relatively soon, potentially, so even before trial, that dissonance is unbridgeable, then you can either decertify altogether, or you can carve out the bits where dissonance is not unbridgeable or has been overcome, and you can carve that. Go ahead.
Why, given that there is a suitability requirement, why shouldn't those matters be addressed at least at some level at the certification stage, rather than leaving it all to later on?
And they are addressed at some level at the certification stage by requiring some evidence, not no evidence, and that it goes on to the indirect purchaser level, as opposed to not going to the indirect purchaser level at all. And I do restate this, and I probably will again tomorrow. Let's not forget that this is a sum basis in fact test, which is two parts interwoven, according at least to the Canadian case law. Is there a credible or plausible methodology that is not purely theoretical or hypothetical? So we are treating this as though they are two completely separate things, the first sentence of 118 and the last sentence of 118. But the Canadian cases say that is absolutely not the right approach. And we're supposed to be applying the approach as it's set out in 118. And we have a case where at this gateway stage, it is accepted all round that we have a credible or plausible methodology. Indeed, it's in general terms, it's the same as that of Mastercard itself, and the tribunal accepted that. So I don't accept that there's no analysis at the certification stage here, and it's a question of where does one draw the stringency of the meaningful screening test. What the Canadian case here it says is it should be a purposive, not overly restrictive. And at paragraph 36 of the same judgment, it describes it as a generous approach and says it's particularly important to do that at certification. And so let me make another 3 points, which you may have heard at least in part before. The first is that, as one of the other cases I will take you to tomorrow shows, it is not, in fact, even that reasonable to expect at considerable expense an expert for the applicant to have gone around seeking to obtain masses of data from lots of other sources before even knowing what that expert is going to get from the other side to the very litigation in question. That is paragraph 107 of the Hewitt case in the Court of Appeal in BC. I'll take you to that tomorrow. And secondly, as quoted in that case from the further Court of Appeal case in Finian, it's pointed out that there isn't an unlimited budget at the CPO stage. This is expensive business. Having an expert opine as to masses of data across the board at this preliminary stage in a funded case. And then there's a third point, which to some degree is borne out by the intervention from which is, and this is picked up as well in Dr. Velanowski's first report, it is that you don't even know for sure quite how you're going to apply the methodology or how you're going to finish off the methodology until you've seen what data that there is. And the critical source of that is from the other side. And those are all reasons why you shouldn't be setting the bar too high at the certification stage. But it's not as though that's a problem, because as I said, if it turns out that you've demonstrated the suitability of this critical question of loss at the certification stage by showing that some of it's gone on to that level of the chain, then after that, you can amend, you can create subclasses, or you can decertify. And in that sense, your points, Lord Sales, can easily be met. If it's unduly burdensome for the defendant, it can get trimmed down. So that's my answer to that point.
Yeah, thank you.
I'm very grateful. And so Hollick is the case. I've read you, I'll just take you to the last little bit in paragraph 16. Halfway down, this is on MS 2207. In Ontario, there is not a preliminary merits test, and thus certification stage is decidedly not meant to be a test of the merits of the action. And as I will show you tomorrow, when I go back to sections 47, B5 and 6, and Rule 79, that's the same structure in our legislation. What you have is a focus upon form, the suitability of collective actions as a matter of form on the one hand, in certain provisions, and in contrast to that, on the other hand, you have a focus in other provisions upon merits, that summary judgment and strikeout. And what you're supposed to be doing here, and what the tribunal should have done here, was focus only upon the former, but it demonstrably strayed into the latter. And it did that, and again, I'll show you the detail tomorrow when we go to the CAT judgment and the Court of Appeal judgment, in what the Court of Appeal described as being an assessment of, quote, the probative value, unquote, of the some evidence that we did put forward. And to give you an example on that score that Mr. Hoskins has already taken to you, it's, Lord Leggatt, your point about the RBB report. Well, it may well be that the RBB report showed some data that was difficult, complex, and difficult to interpret. Well, so what? That's an assessment of the probative value at the trial stage of the some evidence that we did put forward. That's not what we're doing here. That's an assessment that you would do if you were conducting, say, a summary judgment or a strikeout under a different rule with different criteria. And it doesn't end there, because the same approach of critical, skeptical, probative value analysis was adopted by the tribunal as regards other types of evidence. It's in fact interesting that Mr. Hoskin picks on RBB, because that's the one where in section 6 of the original expert report, the expert is at pains to point out that that is not relied on to any particular degree, because it doesn't relate to the right type of data. Anyway, reverting now, I'm just going to address you. I may have already done this in the context of answering the questions. I was going to address you on the purposes of certification. And I'm just scanning this because I may be able to move on. I've made the point that it's critically a matter of form at certification. Should it proceed as a matter of form as a collective, or as what is we'll see tomorrow when we come to the Microsoft judgment in more detail? Instead, should it be what is described there as an, quote, inefficient multitude of proceedings? That's the key question. Should we, as a matter of form, do it collectively, or should we proceed by, in this case, 46.2 million individual claims? And I've already addressed you on the key point about why commonality is central to that issue. If the loss questions have commonality in the sense that they are same, similar, or related, it means that they can be addressed across the board for the class. And that makes great sense in terms of suitability. Because if it turns out that there has been loss passed on to that level of the chain, if it turns out, then the claim has been advanced for all of the class members. But if it turns out that I can't demonstrate, I didn't have a plausible or credible methodology to demonstrate any loss to any purchaser at the indirect purchaser level, well, it would also advance the claim. It's just that it would advance it against me. I would lose. And what you're doing, in my respectful submission at this certification stage, is asking yourself, is it sensible, is it suitable to proceed in this collective manner, because you can avoid a duplication of fact finding and legal finding, because these critical questions of loss are to be addressed in common. And Lord Leggatt, that's why, I appreciate I'm going back now a little bit, but that's why it uses this phrase commonality in 118 process of Microsoft, because it recognizes that at the certification stage, when you're addressing yourself to the question of form, as regards an aggregate damages case that's talking about indirect purchaser losses, the critical issue is, has it passed to that level? If so, it makes sense to carry on. If it hasn't, you're finished. And this point is well explained in a passage about advancing the litigation in another Supreme Court case in Canada, which is to be found, the case of Godfrey, which is to be found beginning at MS 2221. And the passage that I'd like to take you to is paragraph 109, and that's to be found on MS 2298. So this is picking it up at, in fact, the previous page, 2297. You will see that the court here is talking about the exact passages in Microsoft, Process versus Microsoft. So the indented citations are Process versus Microsoft. And you will even see that although the paragraph number is not there, the final indented citation begins, in my view, yes, my lords, that is paragraph 118. That's why you recognize it. And you can see that in the paragraphs at the end. The brackets, the parentheses at the end, paragraphs 114 to 118. And they go in, so in 107 of Godfrey, so this is a Supreme Court case in Canada that came out only a few months ago. It's talking about what does 118 mean? What 114 to 118 mean? And it's the learned, this is an 8-person majority judgment versus 1 dissent. And so this is the majority judgment. The court was employing, I'm reading from 107, the court was employing the term class-wide basis synonymously with indirect purchaser level. Microsoft therefore directs that for a court to certify loss-related questions as common issues in a price-fixing class proceeding, it must be satisfied that the plaintiff has shown a plausible methodology to establish that loss reached one or more purchases. That is the level, the purchaser level. For indirect purchases, this would involve demonstrating that direct purchases passed on the overcharge. So it is completely beyond doubt what the test actually says. Lord Legate.
Sorry, Lord Legate, you need to unmute.
Sorry. As I read this judgment, for example, paragraph 108 and the others, the reason why they're focusing on loss reaching this level is in order to establish liability, because they're taking the view that in order to show that you have a cause of action or claim in tort, you have to show loss, and that requires just some loss, however small. But that isn't the same, it still seems to me, as the question of whether aggregate damages are a suitable way of calculating the loss, which is a different and later question. And, you know, you might not need aggregate damages if you could get individual damages, for example, but it's not the question of, it's not a question of establishing liability, which is what the commonality requirement is all about.
Well, with respect, my lord, we simply don't agree with that. This is under the heading on page 2294 of what is the standard required to certify loss as a common issue. Mm-hmm. And it's talking about the certification stage and the standard at that stage. It's not talking about liability, and it's saying look at paragraphs 114 to 118, which are cited, indented. And then it's explaining what they are, what they mean. And what they're saying in 118 and 119 is that you have to ask yourself the question at the certification stage of whether or not certification will, and I'm reading here from 118 and 119, will it, quote, significantly advance the litigation? And what they say at 119, so this is at certification, you're saying, is it sensible or suitable to proceed in this form as opposed to some other form? Question, will that form or the other form, will it advance the litigation? Answer, it will if you've got a common issue on aggregate damages in the manner that I am describing it. And why? Why is in 109. It says, second sentence, a common issues trial has the potential to either determine liability or terminate the litigation. Either scenario advances the litigation towards resolution. Hence, here, if it cannot be shown that loss was suffered by any purchasers at the indirect purchaser level, then none of the indirect purchasers have a cause of action, and the action with respect to all the indirect purchasers would fail.
Well, that seems to be exactly my point, if I may say so, that it's all about establishing whether there's a cause of action at all, for which you need to show that there's been some loss suffered, because that's an element of the cause of action, which is different from the question of whether you quantify it by making an aggregate damages award.
Well, my lord, I should come, I can see the time, I should come back to this tomorrow. That is not what's going on here. And what the cases make extremely clear is the question at the certification stage is what is the correct form of the litigation, collective or otherwise. And so that may be a convenient moment if it suits the court.
Yes, thank you very much indeed, Mr. Harris. Thank you. We'll sit again tomorrow at 10 o'clock.
I'm grateful.
Thank you very much.